You're looking sharp, Juan Ramon. Looking forward to participate.
Good afternoon, Excellencies, dear colleagues. It's 3 o'clock, so I think it's time to start. And I welcome you, Excellencies, dear colleagues. It's 3 o'clock, so I think it's time to start. And welcome you. Some echo here. Just a second, please. Okay, I will set now. Are we ready now? I think we're ready. Yes, I think we're ready. We're ready to start. Excellencies, dear colleagues, good afternoon to all of you. I welcome you to this Arria Formula informal meeting convened by Mexico under the theme Upholding the Collective Security System of the UN Charter, the use of force in international law, non-state actors, and legitimate self-defense. As this meeting is being broadcasted live through UN Web TV, I wish to start by thanking the members of the Council for making it possible. Before we go into substance, let me kindly remind you to mute your microphones until the floor is given to you and to mute them again as you finish. We're very pleased to have a long list of countries registered, so I kindly ask you to restrict yourselves to a 3-minute participation as convened. If necessary, and only if necessary, I will remind you to do so if you are exceeding the allocated time. Moving on to the substantive agenda, as indicated in the concept note, the objective of this meeting is to discuss the legal scope of Article 51, in particular, the interpretation that has been given to this provision of the chapter against non-state actors in the context of counterterrorism, as well as the precedents that these actions could set for other cases in the future. To kickstart our conversation, we have the pleasure of having with us today Professor Naz Modir-Sadeh, Director of the Harvard Law School Program on International Law and Armed Conflict. Professor Modir-Sadeh, it's an honor to have you with us. The floor is yours.
Thank you very much, Ambassador de la Fuente, and thank you very much for having me. Excellencies, distinguished representatives, ladies and gentlemen, I am grateful to the Permanent Mission of Mexico for inviting me to this timely Arria Formula meeting on a vitally important topic. Over the next 15 or so minutes, I will seek to shed light on the implications of state silence concerning the right of self-defense in counterterrorism contexts. My core message is that despite the significant stakes in this debate for all members of the international community, the law governing self-defense is being shaped and applied in counterterrorism contexts without the active and routine participation of the vast majority of states. From my perspective, this situation is unsatisfactory. To effectively maintain international peace and security, all states should address it as a matter of priority. Not participating in these debates comes with a cost. Intentional or otherwise, state silence contributes to normative uncertainty. Further, in practice, silence might function, legitimately or not, as a kind of tacit support for particular claims in the law of self-defense. All member states, all of you in this room and those not participating in today's meeting, should be aware of the potential effects of silence as you deliberate on whether to weigh in or remain on the sidelines. Let me explain. Over the last several decades, numerous debates concerning the legal regulation of the threat or use of force in international relations have generated volumes upon volumes of wide-ranging arguments. These debates, which often entail life and death stakes on an enormous scale, go to the heart of the collective security regime. One of the issues that has rightly generated extensive commentary relates to military action by a state against a non-state actor in foreign territory without that territorial host state's consent or the Security Council's authorization. Numerous strands of the debate and the practice underlying it can be traced back several decades, if not longer. That practice includes an evidently growing number of purported exercises of the right of self-defense against those non-state groups. This part of the self-defense debate has gained particular attention and heightened relevance as more of the states taking military action against these groups characterize the situations as counterterrorism contexts. Many of these specific claims to self-defense assert that the territorial host state is unable or unwilling to obviate the threat posed by the non-state group. Undoubtedly, these questions involve core matters of state sovereignty, not least for territorial integrity and security. Some international actors believe that the states engaging in these types of military action should be heard most loudly in this conversation, and that the law should, first and foremost, take account of those states' concerns. Yet from my perspective, the prohibition on the threat or use of force in international relations and the collective security system ought to be safeguarded by all states for the interests of all states. Indeed, in designing the charter system, moreover, states are the primary international actors responsible for forming, modifying, and terminating legal rules. Despite this primary responsibility, it seems that today, in practice, a handful of scholars who invoke perceived silence in this area may be exerting more significant influence than many states in shaping this part of the self-defense debate. Scholarly discourse certainly has a vital role to play here, yet I believe that this discussion needs to move from the pages of academic volumes to the chamber of the Security Council and the hall of the General Assembly. Bear in mind that today's specific debate is not the first, and nor will it be the last, topic concerning the prohibition on the use of force, where state silence might be accorded legal effects. For example, at least for certain international actors, state silence may also play a role in debates over so-called anticipatory self-defense, humanitarian intervention, and rescue of nationals abroad. In a 2019 report for the Harvard Law School program on international law and armed conflict titled Quantum of Silence in Action and Use ad Bellum, my co-authors, Professor Gabriella Bloom and Dustin Lewis, and I sought to help raise awareness of the consequences of silence as an international law argumentative technique in the law governing the use of force. In this report, we take no position on the substantive merits of the various and often opposing legal views elaborated in the contemporary debates, nor do we take a position on whether there is any reasonable room for such debate at all. Instead, we take the existence of these debates as a given and focus on how international actors have sought to use state silence as purported proof of tacit support for their respective positions. From our perspective, the questions of what silence means as a matter of international law and under what conditions it may and should be relied upon merit closer attention and discussion. That is especially the case, in my view, concerning the scope of the contemporary right of self-defense. To be certain, a state may intend for its silence to have legal effects, but state silence may alternatively result from lack of awareness or from diplomatic, political, strategic, or other non-legal considerations. Indeed, it may very well be that states do not mean for their silence to signify support or objection to any particular legal viewpoint. Nevertheless, state silence concerning relevant self-defense claims is being imbued with legal significance by various international actors. And more often than not, those invocations are made in favor of broad claims to resort to force. Whether or not silence has or should have legal significance in this area is a complex question. I don't have time this afternoon to elaborate on its various nuances, but the short version is that arguably silence may be capable under strict conditions of contributing to an interpretive agreement of a charter provision or the identification of a rule of customary international law. But even those limited forms of qualified silence ought not to be lightly presumed. Instead, we argue, there is a strong, if rebuttable, presumption that silence alone does not constitute acceptance of a self-defense claim. Be that as it may, states and other international actors should be aware that as a practical matter, their silence might play a role in identifying and developing the legal rules. States that do want to participate actively in this debate do not currently have reliable access to all relevant information, even self-defense related information that member states are obliged to report immediately to the Security Council. Since the advent of the United Nations, a number of avenues have been pursued to make it possible for member states to obtain information relevant to these Article 51 self-defense communications. To date, however, none of those efforts has resulted in a timely and authoritative system to identify and evaluate those communications. For example, the repertoire of the practice of the Security Council and subsequent supplements thereto provide a record of the evolving practice and procedure of the Council. In the 2019 to 2020 period, for the first time in the repertoire's 68-year history, the Secretariat adapted its working methods to enable contemporaneous coverage of the Security Council's practice. Yet the repertoire does not necessarily reflect the Security Council's views regarding what qualifies as an Article 51 self-defense communication. Perhaps more to the point, it is far from clear that the Security Council itself determines which communications qualify in the first place. Partly as a result, there remains no single place to turn, whether on the Security Council website or in any council document, to find all qualifying self-defense communications, let alone responses to them by the council or member states. In light of this situation, alongside the HLS-PLAC report on silence, our research team created a catalog of apparent Article 51 self-defense communications from 1945 through 2018. Our researchers identified over 430 apparent self-defense reports made to the Council in that period. The researchers also recorded whether or not the Security Council responded in the sense of a provision in an act of the Council to those communications. According to our analysis, the Security Council reacted formally to about 1/10 of the identified self-defense communications. The lack of an accessible, comprehensive catalog of contemporaneous self-defense reports raises technical burdens and interpretive challenges for member states attempting to contribute to today's debate. It seems that a state seeking to be aware of Article 51 self-defense communications in real time needs to consult the full text of all Security Council documents to identify candidate reports. The state then needs to determine whether a particular communication qualifies as an Article 51 self-defense communication, and it must do so without authoritative guidance from the Security Council or member states writ large. In terms of scale, hundreds of communications are made to the Security Council annually. For example, in 2018, over 1,000 documents were given an S/document symbol. In comparison, the HLS PLAC catalog records that in 2018, only 4 apparent Article 51 self-defense communications were submitted to the Council. Self-defense reports are effectively needles in a haystack. In the current context, states are not made aware of which communications count in the eyes of the Security Council as Article 51 self-defense communications. In these circumstances, it would seem difficult to consider a state's lack of reaction to the legal claims made or the actions described in those reports as deliberate or even conscious. With this in mind, I would like to close with 3 questions for member states' consideration as they reflect on these issues. First, what are the key legal, political, and strategic issues for member states in deciding whether or not to take part in the substantive and procedural debates on the contemporary right of self-defense? Second, should state silence or inaction have a role in identifying and modifying the legal rules on the right of self-defense? And third, what steps would be necessary to provide all member states with systematic and timely access to qualifying Article 51 self-defense communications? Excellencies, in conclusion, member states ought to consider whether they are comfortable with a cornerstone of the charter system possibly shifting without their views being taken into account and without reliable access to relevant information. Much hangs in the balance, including whose voices will be heard in developing the law. I look forward to this critical conversation. Thank you.
Thank you very much, Professor Modir Sadeh, for your comprehensive, insightful, and challenging briefing, which offers much food for thought. We really appreciate your being with us. Allow me begin with a brief remark on my national capacity. Excellencies, 75 years ago, a new era of international relations began. An era where peace would be pursued and secured through the rule of law, and war would be outlawed once and for all. To ensure this, we established a collective security system in the UN Charter, which continues to be the cornerstone for the maintenance of peace and security. This system is relatively simple. It comprises 1 rule and 2 exceptions. The rule: the threat or use of force is prohibited between states. The exceptions: when the Security Council decides to take foreseeable action in accordance with its Chapter 7 powers, and when states exercise their inherent right of self-defense in accordance with Article 51 of the Charter. No more, no less. In recent years, however, some states have invoked the right of self-defense to justify the use of force in the territory of another state without its consent, allegedly in response to armed attacks by non-state actors. Sometimes, self-defense has been invoked even before an actual attack has occurred. This has been done under the premise that either a state is unwilling and unable to take action, or that it is not exercising effective control over its territory. Mexico has expressed its concern regarding this practice for several years in different debates, both at the Security Council and in the General Assembly. Today, we will focus on three main aspects of these controversial practices that deserve an in-depth analysis. First, from a substantive point of view, Mexico rejects the propositions of invoking self-defense on the premise of the so-called unwilling and unable doctrine, or on the lack of effective control as being legally sound. These caveats are not found within Article 51 and go beyond the scope of this provision, which, because of its nature and aim, was carefully and purposely drafted in a narrow way. They also allow for a dangerous and unilateral margin of interpretation, which can have negative, unforeseen consequences in different contexts. Second, from a procedural point of view, we find it troubling that reports submitted in this context have mostly been drafted in general terms, and that some have been submitted ex post facto as a justification of military action. These, combined with the absence of a discussion by the Security Council, runs the risk of offering a blank check for states to use force as they deem fit, putting at risk the structure of the collective security system. Thirdly, there is a great need for more transparency regarding this practice. Even though reports submitted to the Security Council under Article 51 are public, they are not circulated to all UN member states, and they are practically inaccessible. Given the fact that these reports address instances in which force is or will be used, they are of the interest of the entire international community. Given the opacity in which these situations occur, silence by states cannot be considered as a sign of acquiescence. To conclude, our actions and words matter, and they have the power to consolidate international law. Without an inclusive, transparent, and thorough debate on these issues, we run the risk of reshaping the law and thus fracturing our collective security system. This is the time to uphold the UN Charter and to jointly discuss how can we best address current threats to international peace and security, ensuring that in so doing, we fully adhere to the international rule of law. Thank you. I will now move to our speakers list and will first give the floor to the members of the Security Council. I give the floor to the delegation of Vietnam, and I see we have with us the PR of Vietnam. He, you have the floor. Welcome.
Thank you, Mr. Chairman. The principle of non-use or threat of force is one of the most important principles enshrined in the UN Charter and international law. But it is deeply troubled that in recent years, several instances of use or threats of use force have been witnessed in international relations, running counter to the UN Charter and posing serious threats and challenges to international peace and security. The right to self-defense was invoked in increasing frequency to justify the use of force, including in response to armed attacks by non-state actors, in particular terrorist groups. In that context, my delegation would like to share the following points. First, our collective and individual imperatives must continue to be development of friendly relations among nations and building a culture of upholding the UN Charter and international law. We must abide by the principles of sovereignty, territorial integrity, non-interference in domestic affairs, and non-use or threats of use of force, and peaceful settlement of dispute. The Security Council needs to further uphold full implementation of and compliance with international law, strengthen the role and validity of international law in the maintenance of international peace and security. Second, it is the obligation of each and every state to peacefully resolve dispute and refrain from threat or use of force. The Council should make full use of cooperation with international organizations and legal bodies in promoting the resolution of disputes, preserving peace, and preventing conflict. Third, the UN Charter exhaustively provides for lawful use of force. Any use of force without Security Council authorization or not in the exercise of the right of self-defense are without legal basis. Any attempt to reinterpret or abuse of UN Charter drive us down a very dangerous and unsettling path. In that spirit, we fully support the inclusive and transparent dialogue and enhance an exchange of the views and practice in the implementation of Article 51. And we also believe that the Council should continue to improve its working methods to increase the accessibility by member states to its document and to facilitate discussion. Vietnam remains strongly committed to upholding the role of the UN Charter and international law as an indispensable tool in the maintenance of international peace and security. I thank you, Chair.
Thank you very much, and I will give the floor now to the Russian Federation. I want to thank the presence of the PR of Russia. You have the floor. We can't hear you.
Now it should be better. Yeah. First of all, I would like to thank and express gratitude to the Permanent Mission of Mexico for organizing this important discussion. And I would like also to thank Professor Madirzadeh for her briefing. In recent years, we have witnessed an unprecedented proliferation of notifications to the Security Council under Article 51 regarding the use of force, allegedly in self-defense by a number of states against terrorists on the territories of Syria and Iraq. At the same time, we also saw a number of responses, mostly from the government of Syria, which strongly deny the qualifications used in these notifications and describe the actions of relevant states in terms of aggression, occupation, and other forms of illegal use of force. We also know what happens on the ground and have a chance to compare the situation with the language of notifications, which too often do not coincide. This situation became an elephant in the chamber of the Security Council that nobody wished to notice. So we congratulate Mexico for its courage to put this elephant in the limelight. The issue of the use of Article 51 against non-state actors is a difficult one because this article was not intended for this purpose. We must recognize that. It was drafted in order to describe the right of self-defense against armed attacks of states. However, the language of this article allows for a broader interpretation. This broader interpretation became practical after 9/11, which demonstrated that an attack of terrorists may rise to the level of an armed attack of a state. It was confirmed in the Security Council Resolution 1368 in 2001. However, it doesn't mean that any terrorist attack in a cross-border context gives rise to the right of self-defense. Firstly, the criteria applicable to the definition of an armed attack must be fulfilled, in particular in terms of the magnitude of the event. Secondly, the position of the government of a state from whose territory terrorists strike must be carefully assessed. It is one thing when a government directs and supports such an attack, and another if it uses all available means to fight such terrorists and is open for cooperation with other states. In the latter case, it is obvious that cooperation and consent of the government must be requested. The level of bilateral relations or lack thereof may not be the ground for avoiding this requirement. Going back to the recent notifications circulated in the Council regarding the use of force by a number of states on the territory of Syria, we would like to highlight a couple of points. There is no Security Council resolution authorizing the use of force on the territory of Syria. In their notifications, states refer to collective self-defense of Iraq against ISIL as the legal basis for their actions. However, Iraq itself did not claim self-defense against ISIL on the territory of Syria. Indeed, it has asked for assistance in the fight against this terrorist organization, but it didn't specify that such assistance should take the form of the use of force on the territory of Syria. Secondly, the government of Syria is fighting ISIL by all available means. In this regard, we do not see any legal ground not to seek for the government's permission for the use of force on its territory, or not to coordinate the efforts. This is even more relevant in light of the fact that Syria offered cooperation to all states in the fight against ISIL. Thirdly, and even more significantly, armed activities by a number of states on the territory of Syria go far beyond any action which may be qualified as self-defense against ISIL. We observe use of force directed against Syrian army or in support of armed groups who oppose the government, and even occupation of parts of the territory of Syria, in particular for the purposes of denying access to oil fields on the territory of the state to its own government while providing this access to opposing armed groups. In this regard, we would like to emphasize that circulation of Article 51 notifications to the Security Council and the lack of immediate reactions from states does not and should not mean that actions taken in accordance with them gained legality or that such conduct contributes to the formation of a new norm of law. The legal architecture of collective security, of which Article 51 is a part, is the highest achievement of contemporary legal order based on the UN Charter, and nobody should be abusing it. I thank you, Mr. Chairman.
Thank you very much. And I give the floor now to the PR of Ireland.
Thank you very much indeed, dear Juan Ramon. And I want to congratulate you on your maiden Arria and to say that we're delighted to be with you today. And thank you for bringing such a really interesting subject to our attention. I would also like to thank Professor Modir Zaidi for her enlightening presentation. As member states, of course, we're each of us aware that the prohibition on the use of force that's set out in Article 2.4 of the Charter is the starting point for the Council's primary responsibility for maintaining international peace and security. As one of the two exceptions to this fundamental rule, therefore, Article 51 clearly deserves serious consideration by the Council. As identified in the concept note for this Arria meeting, and as you've just set out, Professor Modir Zaidi, I did very well the first time, Modir Zaidi, excuse me, a barrier to informed consideration of Article 51 is states' difficulty in identifying and accessing communications submitted to the Security Council pursuant to that article. We believe this is due to two very practical issues. The first relates to content and the fact that states, when actually submitting such communications to the Council, don't always explicitly state that they're doing so, and I quote, in accordance with Article 51. This clearly, undoubtedly, makes it difficult for the Secretariat to categorize such communications, while at the same time makes it difficult for other states to search for and indeed respond to relevant communications, even after they've been published as documents of the Council. Though we accept that the inclusion of such a reference is not a requirement of the article of Article 51, we urge all states to consider adding one to communications submitted under this article. The second question I wanted to point to is how best to bring these documents to the attention and awareness of the wider membership and ensure greater efficiency in their circulation. These communications, we know, they're not confidential, and they're published in the UN's digital library as a document of the Council. However, they are published and circulated without explanation as to their content, and so very often may get lost in the flood of communications received and circulated by the Council on a weekly basis. As a newly elected member, we are of the Security Council, we are acutely aware of the burden this places on states already struggling to keep pace with the high volume, I underline high volume, of correspondence received on a weekly basis even from the Security Council. For those states not on the Council and without the resources to follow such matters closely, it's even more difficult to keep up or to keep track of that correspondence. Ensuring transparency by better publicising documentation received and published by the Council is important to my country, to Ireland, as a member of the Council, as a member of the ACT group, and of course, as a representative member state in the wider UN family. Such transparency and openness is vital to understanding not only how the Council operates, but also importantly, how states understand their obligations under the Charter. We therefore urge the Secretariat Security Council Practice and Charter Research Branch to consider ways to better and more efficiently distribute and highlight communications submitted under Article 51. We acknowledge that such a request may require additional resources and comes at a time when the backlog in the publication of the repertoire is still an issue. The Secretariat has worked in recent years to reduce the backlog significantly, and Ireland is one of the many contributors to the Secretariat's work in this regard. However, additional contributions are required to ensure that the Secretariat can complete its work in a timely fashion each year, and we call on all member states to ensure their funding remains available. If these two steps, simple, pragmatic steps, were taken, they would go some way to addressing the gap in information identified by Mexico and ensure that states are fully equipped to consider this issue in the future. Thank you very much indeed, Mr. Chair, dear Juan Ramon. Thank you.
Thank you very much, Geraldine. And I will give the floor now to China, please.
Thank you, Chairman. China welcomed this Arria Formula meeting, initiated and organized by the Mexican Permanent Mission. Thank you for that, Ambassador. We would also like to thank the briefer for her very insightful briefing. Maintaining international peace and security is the primary purpose of the United Nations. As enshrined in the preamble of the Charter of the UN, we, the peoples of the United Nations, determined to save succeeding generations from the scourge of war. The use of force relates to the purposes and principles of the UN Charter, the international order based on international law, and has great impact on international peace and security. It is of great concern to all parties. In this regard, China would like to share the following points. First, the principle of non-use of force must be firmly safeguarded. All members shall refrain in their international relations from the threat or use of force. This is a norm of international relations and a fundamental principle of international law established by the UN Charter. It's interrelated with each other, with other principles established by the UN Charter, including sovereign equality, non-interference in internal affairs, and the peaceful settlement of disputes. All these principles together constitute the cornerstone of international consensus on the maintenance of international peace and security. At the high-level meeting to commemorate the 75th anniversary of the UN, Secretary General Guterres noted that a great achievement of the United Nations was avoiding a third world war and the military confrontation between the major powers. The principle of non-use of force has made significant contributions in this regard. Second, the right of self-defense must be exercised in strict accordance with international law. Self-defense is an exception to the principle of non-use of force. The provisions on the right of self-defense in Article 51 of the UN Charter should be interpreted faithfully, in good faith, and without abuse. The exercise of the right of self-defense shall be in strict compliance with the provisions of the UN Charter and the relevant rules of customary international law. The use of force against non-state actors in the territory of another state, which is for the purpose of self-defense, shall be subject to the consent of the state concerned. No country should interfere in other states' internal affairs under the cloak of counterterrorism or use force arbitrarily in the name of preventive self-defense. Third, the integrity and authority of the Security Council must be firmly upheld. The Council has the primary responsibility for maintaining international peace and security, and plays as the core of the international collective security mechanism. In exercising the right of self-defense, member states should fulfill their reporting obligations to the Security Council in accordance with the UN Charter. On major issues concerning international peace and security, member states should respect the authority of the Security Council, support its work, and implement its resolutions. No country is allowed to bypass the Security Council or pursue a selective approach to advance its own interests. Ms. Chair, as a founding member of the UN and a permanent member of the Security Council, China is ready to work with the international community to uphold multilateralism, pursue the rule of law, oppose the unlawful use of force, defend the collective security mechanism, and safeguard the international order and the international system centered on the purposes and the principles of the UN Charter. Thank you, Chair.
I thank China for their remarks and give the floor to France.
Bonjour et merci beaucoup. En l'absence d'interprétation, je prononcerai donc mon intervention en anglais. Et j'en profite to thank Mexico and Ambassador de la Fuente for convening this meeting and Mrs. Professor Modir-Zader for her insight briefing. France is resolutely committed to the system of collective security established by the United Nations Charter, on which all contemporary international law is based. The prohibition of the threat or use of force is a cardinal principle with two exceptions also provided by the Charter and stressed by Ambassador Lafuente. On one hand, the Security Council decision authorizing the use of force. On the other hand, the right of self-defense. In this respect, Article 51 of the Charter allows each state victim of an armed attack to take, individually or collectively, measures to repel that attack. Under international law, measures taken in self-defense action must meet a number of criteria. In particular, they must be proportionate and not go beyond what is necessary to stop the attack. While the victim of attack must be a state, according to Article 51, the status of the aggressor is not delimited or defined. Unfortunately, some non-state groups, particularly terrorist groups, now have the means to commit acts that amount to armed attack against states. Needless to recall that, as we have all witnessed, international terrorism is one of the greatest threats to international peace and security today. And this threat is still growing. France joined in August 2014 the International Coalition Against Daesh, which brings together more than 70 states, which the aim of supporting the Iraqi authorities engaged in the fight against the terrorist group. After the Paris attack in November 2015, France's military action against Daesh targets, which was justified by collective self-defense, could also be based on individual self-defense in accordance with Article 51 of the Charter. In its fight against terrorism, France attached paramount importance to the protection of civilian population and to respect in all circumstances international law, in particular international humanitarian law, the law relating to the protection of civilian and international human rights law. As a permanent member, France ensured that the Security Council acts as the guarantor of international legality when exercising its primary responsibility for the maintenance of international peace and security. To achieve this, it is crucial that the Security Council be immediately informed of measures taken under Article 51. To touch upon a point made by Professor Modizadeh and try and answer to point 3. The Charter does not impose any particular formalism, but it should be noted that in practice, such measures are most often notified in the form of a letter to the presidency of the Security Council. Experience shows that the format and wording used differs substantially from one notification to another, and it is not always easy to determine whether such notifications fall within the scope of Article 51. To conclude, the full and timely information of all member states of these notifications also contribute to the transparency and inclusiveness of the Security Council, as stated by previous intervention. Thank you.
Merci beaucoup, and I will give the floor now to the United States. Ambassador De Laurentiis, the floor is yours.
Thank you very much, Mr. Chairman, and thank you to Mexico for organizing this Arria session. Good afternoon, colleagues. I'd like to join others in thanking Professor Modizadeh for her presentation. We read with great interest her and Dustin Lewis's 2019 study on Article 51 of the UN Charter. The inherent right to use force in the exercise of individual or collective self-defense against non-state actors is well established. Excuse me. For centuries, states have invoked the right of self-defense to justify taking action on the territory of another state against non-state actors. Since the terrorist attacks on September 11th, 2001, 19 different states have identified or referred to non-state actors in their Article 51 notifications. But the United States agrees that the doctrine of self-defense is not a license to wage war globally or to disregard the borders and territorial integrity of other states. In particular, the exercise of the inherent right of self-defense is subject to the customary international law requirements of necessity and proportionality. Necessity requires states to consider whether actions in self-defense that would impinge on another state's sovereignty are necessary. That is, whether measures short of force have been exhausted or are inadequate to address the threat posed by the non-state actor emanating from the territory of another state. This consideration entails an assessment of whether the territorial state is able and willing to mitigate the threat emanating from its territory, and if not, whether it would be possible to secure the territorial state's consent before using force on its territory against a non-state actor. But this legal standard does not dispense with the importance of respecting the sovereignty of other states. Applying the standard ensures that force is used on foreign territory without consent only in certain exceptional circumstances, specifically those in which a state cannot or will not take effective measures to confront a non-state actor that is using the state's territory as a base for attacks and related operations against other states. This leaves a law-abiding nation only the choice to respond in self-defense. Turning to the content of Article 51 notifications, Article 51 does not impose any requirement on what specifically must be included, other than a description of the measures taken in self-defense. State practice has varied with respect to the content of Article 51 notifications. Although the Article 51 notification may include a detailed legal justification for the measures taken, this is not required. The notification is intended only to put the Security Council on notice of the measures taken. Finally, the United States favors transparency. The United States submits Article 51 notifications with the expectation that they will be publicly available. We note that all 51 notifications are electronically available on the UN documentation website to all UN member states and the public at large, in addition to being noted in the repertoire of the practice of the Security Council as that publication is updated. We are prepared to work with other council members through the informal working group on documentation and procedure and with the UN Secretariat to explore ways to make such letters more easily accessible. Thank you.
Thank you very much for your remarks, and I give the floor now to Norway.
Thank you, Ambassador, and thank you to Mexico for this event, which sheds light on a complex but important issue of our collective security. Thank you also to Professor Modir-Sadeh for her insightful briefing. We welcome the inclusive format of this discussion, as it is an opportunity for us also to offer a few remarks. Norway's primary foreign policy interest is to prevent any undermining of the international legal order and multilateral governance system, which are so critical for our security, economy, and welfare. Full respect for international law, not least the UN Charter, is the very foundation of our work in the Security Council. We agree that it is in our interest that the Security Council is as transparent as possible. This includes in the matters before us today, and it is necessary to discuss whether more can be done to facilitate this. We see that the Security Council could, for example, agree that all Article 51 reports should be immediately circulated to all member states and be made publicly available. And likewise, any response to Article 51 report should also be circulated and made publicly available. In this regard, given that the Security Council often receives a large number of letters of any one conflict, it would also be a useful practice for all Article 51 reports to be clearly labeled as such by the sending member state. Any lack of action by the Security Council following receipt of a report under Article 51 should not be interpreted as an acceptance of the legitimacy of the use of self-defense in that particular situation. And we should also be careful not to interpret a lack of response or objection from other states to an Article 51 report as an acceptance of its legitimacy. The purpose of Article 51 is first and foremost to ensure that the Security Council is kept duly informed about any use of force and that the factual basis of the action is taken. Colleagues, additionally, on the substantive side, the concept paper raises the question on how Article 51 is to be interpreted with regard to attacks perpetrated by non-state actors based on the territory of other states. While Article 51 is focused primarily on attacks committed by other states, we believe there is a basis in international law to a limited right to use force in self-defense against such attacks in certain exceptional situations. As one such example of an exceptional situation would be our own Article 51 letter to the Security Council on 3rd June 2016, in which Norway reported to the Security Council that we were taking necessary and proportional measures against the terrorist organization ISIL in Syria, in the exercise of the right of collective self-defense at the request of and on behalf of the Iraqi people and territory. Above all, it is important for us to underline that respect for the principles of the UN Charter is vital. The use of force must only be applied as a last resort. The use of military force may sometimes be necessary, but must only be carried out in accordance with international law. To conclude, we look forward to discussing this further, for example, in the informal working group on documents and procedures. The discussion here today certainly provides ideas on how to make necessary improvements. Thank you, Ambassador.
Thank you very much, Ambassador, and I give the floor now to Tunisia.
Thank you, Juan Ramon. I also would like to thank Ms. Naz Modirzada for her presentation. We appreciate the leading efforts of Mexico in bringing this topic front and center at both the Charter Committee and the Security Council. We also welcome the timely legal conversation held over the last few days in the Charter Committee on Article 2, Paragraph 4 and 51 of the UN Charter, which helps inform our present discussion. At the same time, we would like to underscore the prominent relevance of the Security Council for our topic. In particular, this area meeting allows us to steer an open and practical discussion that situates legal rules in their political context, thus reducing the self-contained charter of doctrinal analysis and channeling normative thinking in effective directions. The prohibition of the threat or use of force constitutes one of the foundational principles of the UN Charter and a cornerstone of the contemporary international legal order. Any use of force between states is unlawful and tolerable and unjustifiable outside the framework of collective security and with the exception of individual and or collective self-defense as per Article 42 and Article 51 of the Charter, respectively. The recurring invocation and praxis by states of self-defense in reaction to transnational non-state actors, in particular terrorist groups, seen in the growing number of communications to the Security Council under Article 51, reflects not only the interrelation of Article 51 with Article 2, Paragraph 4 of the Charter, but also tension between the two. There is therefore a need for clarity, caution, and action to avoid any possible abuse of the right of self-defense. Tunisia's core position is grounded in international legality and international cooperation. It is what constitutes our political, legal, and moral compass on this issue. And I would like to further elaborate upon the following. Firstly, the importance of upholding international legality. We underline the fundamental importance of upholding respect for the UN Charter as well as UN Security Council resolutions relevant to counterterrorism. We further stress the purpose of maintaining international peace and security by the United Nations and Article 1, Paragraph 1 of the Charter, with Arab security being paramount. Secondly, upholding the collective security system for the lawful use of force in accordance with the UN Charter. It is to underline within the framework the primary role and responsibility of the Security Council as the guardian of international peace and security with primary international control over the use of force. The Security Council authority, which is based on the consent of all UN member states, must therefore be respected and restored. Additionally, the Security Council should heed the communications received under Article 41 in a timely manner, considering the potential escalation, lapse or relapse into conflict, and take decisive action where appropriate to maintain or restore peace and security. Thirdly, strengthening international cooperation and coordination and counterterrorism. The increasing resource to the transnational use of force in self-defense against terrorist groups reflects the fractured character of the response to terrorism by the international community. By virtue to the principle of necessity, the state hosting non-state actors, in particular terrorist groups, should be given the opportunity in the first place to halt and prevent the attacks by non-state actors through its domestic law enforcement measures and with due observance of the applicable rules of international law. But there is also a need to promote interstate cooperation and coordination, particularly in light of the interplay between domestic and international responses to terrorism. Fourthly, more clarity on the scope and application of the principle of self-defense in counterterrorism contexts. Legitimate self-defense cannot end on a categorical note or a rhetorical flourish. Rather, its semantic justifiability will continue to be debated in a changing political reality that involves new actors and new challenges. There is therefore a need for more clarity and predictability in international legal rules through the progressive development of international law and jurisprudence so as to enhance shared legal norms and understandings and define appropriate forms of state conduct. In conclusion, Mr. Chair, while normative and understanding vary with historical and political context, it remains that more than 75 years after the signature of the UN Charter, the prohibition on the use of force has established itself as a long-term regularity of law and practice. The constant drive must nevertheless be that nations remain amenable and committed to international law and to the rule of law in the pursuit of friendly relations and a just and orderly international system. Thank you.
I thank the PR of Tunisia for his remarks and give the floor now to Kenya. Ambassador Kiboino, you have the floor.
Thank you very much, Chair. Let me start by thanking the permanent mission of Mexico for convening this meeting under Arria formula and for the opportunity to exchange views on such an interesting and complex subject. I also want to thank Professor Modizade for the insightful and thought-provoking briefing. What we all may easily agree on is that this is a rather complex subject and that we are unlikely to dispose of it in a single sitting such as this one. However, the reality and perhaps the beauty of our work today is that we are building upon the blocks of listening to each other, exchanging views, learning from each other, and very importantly, pulling views towards the common goal of the United Nations, which is international peace and security. We have listened keenly to the excellent briefing, which we appreciate, as well as the views made by delegations who have taken the floor before us. And my delegation appreciates that even upon complex subjects such as this one, our discussions create bridges of insight, including on issues that otherwise seem rather difficult. For this reason, we we agree that this matter is relevant for discussion in the Council, but there are also other fora that may progress this discussion in a manner that allows for more in-depth engagements. Additionally, such fora could achieve more than an exchange of views and instead delve into the legal interpretation of its various aspects. In this regard, this meeting counts as a useful block to the aims of such discussion. I wish to just underscore Kenya's abiding commitment to the purposes and principles enshrined in the Charter of the United Nations, which include the respect for sovereignty, equality of all states, the maintenance of friendly relations among states, as well as the obligation to refrain from the threat or use of force against the territorial integrity or political independence of other states. These principles and purposes have served well as a fundamental foundation in the conduct of international relations and should continue to inspire and guide future generations. We find them to be as relevant today in enlightening this discussion as they were when the Charter was first drafted in 1945. And it is our duty as all nations to remain steadfastly dedicated to the implementation and adherence in both letter and spirit. I thank you.
I thank Kenya for his remarks and give the floor to Estonia. Ambassador Alvar, the floor is yours.
Thank you very much, Ambassador. Allow me to thank Mexico for convening this area and Professor Modirzadeh for her intervention. I would like to reaffirm Estonia's unwavering commitment to promoting respect for international law and rules-based international order. In general, use of force in international relations goes against the principles enshrined in the Charter of the United Nations, as all states shall refrain from the threat or use of force against another state. Exceptions for the legal use of force are limited to specific cases mentioned in the Charter. The first such exception is when the UN Security Council so decides in order to maintain or restore international peace and security. The second is self-defense. Article 51 of the Charter, as well as customary international law, grant states the inherent right of individual or collective self-defense. The Charter does not delimit the right of self-defense to cases where an armed attack is organized by a state. The right of self-defense must also exist against non-state actors. The host state has the primary obligation to ensure that its territory is not used to breach international peace and security. However, the activities of the host state are often not sufficient to prevent non-state actors from organizing attacks. In such a case, as the right to self-defense is inherent according to Article 51, it exists also against non-state actors operating in the territory of another state. This has come up in Security Council practice since 2001. Denying states the right of self-defense against non-state actors operating in the territory of another state in principle would otherwise place the victim state in an impossible position. Even so, we need to emphasize that the use of self-defense against non-state actors as well as against any other imminent attacks must remain exceptional and strictly correspond to the principles of necessity and proportionality. The Charter furthermore requires that the notifications be made immediately. We also note that according to the Charter, states have the right of self-defense until the Security Council itself takes measures necessary to maintain international peace and security. However, the Security Council has not always adequately responded to such breaches, and states have therefore retained their right to self-defense in default of Security Council involvement. Finally, let me also assure you that Estonia is open to discuss the ways to enhance the transparency and availability of notifications made under Article 51 and related correspondence. I thank you, Ambassador.
I thank Estonia for his remarks and give the floor to India. Ambassador Naidu, the floor is yours.
Mr. President, let me first thank the Mexican delegation for organizing the meeting on this important topic and Professor Naz Modirzadeh for her excellent briefing. As in the past, we would like to place on record our reservations against the Arria format of meetings, since there have been several occasions when this format has been misused. Mr. President, the theory and practice of the use of force during the 19th and the early 20th centuries legitimized in some ways the resort to war in international law as a procedure of self-defense as long as certain criteria were met. The Covenant of the League of Nations represented a first significant break with the traditional theory and practice and rendered the resort to force as unlawful in certain specific circumstances. While the spirit of the Covenant has been incorporated in various articles of the UN Charter, the customary right of self-defense has and continues to remain unimpaired. Article 2.4 of the UN Charter requires that states refrain from the use of force. However, the drafting history of Article 51 of the UN Charter and the relevant San Francisco Conference report of June 1945 that considered Article 2.4 of the Charter mentions that the use of arms in legitimate self-defense remains admitted and unimpaired. Article 51 also explicitly acknowledges the pre-existing customary right of self-defense as recognized by the International Court of Justice and the UN Security Council by stating that nothing in the present charter shall impair the inherent right of individual or collective self-defense. Mr. President, customary international law has long recognized the principles governing the use of force in self-defense. Exercising self-defense is a primary right of states to be exercised when the situation is imminent and demands necessary, immediate, and proportionate action. Furthermore, Article 51 is not confined to self-defense in response to attacks of states only. The right of self-defense applies also to attacks by non-state actors. In fact, the source of the attack, whether a state or a non-state actor, is irrelevant to the existence of the right of self-defense. Non-state actors, such as terrorist groups, often attack states from remote locations within other host states, using the sovereignty of that state as a smokescreen. In this regard, a growing number of states believe that the use of force in self-defense against a non-state actor operating in the territory of another state can be undertaken if, number one, the non-state actor has repeatedly undertaken armed attacks against the state. Number two, the host state is unwilling to address the threat posed by the non-state actor. And number three, the host state is actively supporting and sponsoring the attack by the non-state actor. In other words, a state would be compelled to undertake a preemptive strike when it is confronted by an imminent armed attack from a non-state actor operating in a third country. In fact, Security Council resolutions 1368 and 1373 have formally endorsed the view that self-defense is available to avert terrorist attacks, such as in the case of the 9/11 attacks. Mr. President, the 1974 UNGA Declaration on Principles of International Law, Friendly Relations and Cooperation among States, in accordance with the Charter of the UN, requires positive action on the part of a member state so as not to acquiesce or tolerate terrorist activities originating from within its own territory, nor allow the territory under its control to be used for terrorism against another state. The Security Council also mandates all states to refrain from providing any form of support, active or passive, to entities or persons involved in terrorist attacks. Despite this, some states are resorting to proxy war by supporting non-state actors such as terrorist groups to evade international censure. Such support to non-state actors has ranged from providing and equipping the terrorist groups with training, financing, intelligence, weapons, to logistics and recruitment facilitation. India for decades has been subject to such proxy, cross-border and relentless state-supported terrorist attacks from our neighborhood. Whether it was the 1993 Mumbai bombings or the random and indiscriminate firings of 26/11, which witnessed the launch of the phenomenon of lone wolf attacks, or more recently, the cowardly attacks in Pathankot and Pulwama, The world has been witness to the fact that India has repeatedly been targeted by such non-state actors with the active complicity of another host state. Mr. President, while we believe that instances where states have exercised the right of self-defense to attack non-state actors located in other states must be consistent with Article 2.4 of the UN Charter, preemptive actions taken to fight the menace of terrorism, even without the consent of the state hosting the non-state actors, meets this criteria because such actions are not of reprisal, since their prime motive is of protecting the affected state's national integrity and sovereignty. Thank you, Mr. President.
Thank you very much. And I will give the floor now to St. Vincent and the Grenadines, please.
Thank you, Ambassador de la Fuente. St. Vincent and the Grenadines welcomes today's discussion, and we thank the Permanent Mission of Mexico for hosting this meeting. We also thank our esteemed briefer, Professor Modirzadeh, for her briefing. Thank you for your remarks. The COVID-19 pandemic has brought into closer focus the intrinsic value of our multilateral system. At a time when many nations the world over face alarming uncertainties over the health and well-being of our societies, the norms and rules of international law offer the greatest assurance against disorder. As a matter of principle, our delegation emphasizes that all states have the right to act in self-defense as a last resort, if and only when absolutely necessary and with proportionality. Notwithstanding, the fundamental principles of non-intervention, non-interference, and the pacific settlement of disputes, as outlined in the UN Charter, should guide all states in their efforts to cooperate constructively and peacefully coexist. Any derogation from these universally accepted norms, wheresoever and by whomsoever committed, severely undermines the ideals of multilateralism embodied in our United Nations. For this reason, our delegation maintains that all forms of unilateral action, whether through militarism or any other form of coercion, should be abandoned, while dialogue, diplomacy, and other participatory tools, such as mediation, are pursued. These are the primary pathways to peace and security. To be sure, there are some contexts within which states may be compelled to use force to protect civilians, dispel non-state armed groups, and defend their sovereignty and territorial integrity. However, there can be no viable substitute for collective action in pursuit of just, lasting, and equitable outcomes. To this end, we underscore the important role of regional cooperation in addressing cross-border challenges, such as terrorism, in a manner which privileges the relevant provisions of international law, including international humanitarian, human rights, and refugee law. To conclude, our delegation underscores that security has always been and will continue to remain a collective project. When parties build trust and mutual respect, guided by the norms and rules of multilateralism, rather than by fear or coercion, peace and stability will flourish. Thank you.
Thank you for your remarks, and I give the floor to the United Kingdom.
Thank you, Ambassador. And let me start by thanking the Permanent Mission of Mexico and our briefer, Professor Modirzadeh, for this occasion and for the opportunity to discuss some of the broader aspects of the right of self-defense, as well as focusing on the reporting requirement under Article 51 of the Charter. The starting point, as we've heard, of any discussion on the right of self-defense must be the prohibition on the use of force in Article 2.4 of the UN Charter and under customary international law. That is a fundamental tenet of the post-1945 international order, although there are certain exceptions to that prohibition. One such exception is recognised in Article 51 of the Charter, which states that nothing in the present Charter shall impair the inherent right of individual and collective self-defence. This reference to the inherent right of self-defence is important because it preserves the long-standing customary international law right of self-defence. It is well established that measures taken pursuant to the right of self-defence are limited to those that are necessary and proportionate to averting the armed attack that has triggered the right. Like many other states, the UK's long-standing view is that a state is not required to wait passively until an armed attack has actually been launched before the right to use force in self-defense arises. Customary international law has for centuries provided a right to use force in self-defense against an imminent armed attack. The diplomatic correspondence following the so-called Caroline Incident of 1837 contains the classic exposition of this right. Similarly, it has long been the view of the UK and many other states that the right of self-defense can be triggered in certain circumstances by armed attacks, whether ongoing or imminent, by non-state actors as well as by states. The Caroline incident itself was an early example involving the use of force in self-defense against non-state actors. However, it's the tragic events of 9/11 and the gravity of threats posed by international terrorism in recent years that have necessitated increasing reliance on self-defense measures in response. The Security Council's unanimous adoption of resolutions 1368 and 1373, recognizing the inherent right of self-defense after the 9/11 attacks, clearly demonstrated that this council deemed those attacks by non-state actors to amount to an armed attack within the meaning of Article 51. Since 2015, the UK has used military force against Daesh in Syria as part of an international coalition, which has the support, whether military or political, of some 60 or 70 states. The legal basis for the coalition's military operations in Syria is the collective self-defense of Iraq in accordance with Article 51. But the UK has also invoked the right of individual self-defense in relation to one military operation within this campaign. The procedural requirement of Article 51, immediately to report to the Council measures taken in the exercise of self-defense, is mandatory, and as the International Court of Justice has made clear, is not without legal significance. Whilst such notifications are often made in a letter to the President of the Council, which may or may not refer to Article 51, the Charter doesn't lay down any particular form for this. Notification could even be oral during a Council meeting. And it may be a matter for interpretation whether a written communication is made under Article 51 or not. Notifications under Article 51 are usually made available promptly to all members as United Nations documents. Those that expressly refer to Article 51 are listed each year in the repertoire of the work of the Security Council. And there is much useful and timely information that's also made available on websites such as the Security Council report and the procedure of the Security Council, edited by Sam Dawes and Lorraine Sievers. We are not convinced that there is a need, or indeed that it's feasible for more in this respect, but we are very happy to work in the informal working group on procedures and documentation if that's what colleagues desire. Finally, I would say on state practice and the work of the Security Council may be relevant in the interpretation of the Charter and development of customary international law, but we agree with Professor Modizadeh that great care is needed in identifying and assessing such practice, and particularly the role of silence in that respect. This becomes clear in the work of the International Law Commission on two of its recent projects on customary international law and on subsequent practice under treaties. The fact that authors sometimes jump to unwarranted conclusions about the significance of silence may be regrettable, but it's not necessarily, in our view, a reason for the Council to change its practice. Thank you, Mr. Ambassador.
Thank you. With the remarks of the United Kingdom, we end the list of the participation of the members of the Security Council. And I thank you for your contributions. We will continue now with the delegations that have requested to take the floor. And we give the floor to the delegation of Liechtenstein, the PR of Liechtenstein. Christian, you have the floor. Welcome.
Thanks so much, Juan Ramon. It's great for us to have an opportunity to participate in this very important discussion. Very special thanks to our briefer, Professor Modizadeh, who has framed the topic in a very, very clear way and raised important questions for the day. Chair, one of the key achievements of the UN Charter is the prohibition of the use of force. When joining the UN, we have all accepted that the use of force is illegal, except when authorized by the Security Council under Chapter 7 or carried out in self-defense in accordance with Article 51. However, Article 51 is increasingly invoked as the legal basis for the use of force without the necessary legal justification. Excessively expansive and unchecked interpretations of Article 51 weaken the international rules-based order as provided for under the Charter. A clear and renewed commitment by the membership is needed with the aim of upholding the Charter's integrity and authority on the provisions governing the use of force. When invoking Article 51, in particular preventively, states owe the UN membership a thorough and convincing justification. As a minimum, this would include evidence of the imminence of an armed attack, as well as of the necessity and the proportionality of the measures taken in response. Mr. Chairman, Liechtenstein agrees that Article 51 reporting also suffers from a significant lack of transparency. Given this deficiency, it is our view that any silence cannot be taken as acquiescence to particular Article 51 positions put forth in the reporting. Procedures should be put in place that improve the transparency of Article 51 reporting so that information is available to all states about relevant communications and positions, allowing states to provide views in response if they so choose. An open and transparent exchange of this building block of the international legal order would enable us to meet the standards we have set ourselves for effective, accountable, and inclusive institutions at all levels in the 2030 Agenda. Mr. Chairman, the UN Charter foresees an enforcement role for the Council with respect to the most serious violations of the relevant rules under international law that amount to acts of aggression. In addition to the tools contained in the Charter, the Council now also has the option of initiating individual criminal responsibility for those who commit the crime of aggression by referring relevant situations to the International Criminal Court. The activation of the relevant law, the Kampala Amendments to the Rome Statute, took effect in July 2018, and we welcome the most recent ratifications of these amendments by Bolivia and Mongolia, bringing the total number of ratifying states to 41. We hope that the law, consensually agreed by the ICC state parties, will guide states in their internal deliberations on the use of force, and this Council in assessing the legality of relevant action taken with a view to ensuring accountability for this supreme crime. I thank you very much.
Thank you for your remarks, and I give the floor now to the PR of Ecuador.
Gracias, Presidente Juan Ramón. Excellencies, ladies and gentlemen, I thank Mexico for organizing this timely Arria Formula meeting, which provides us the opportunity to further analyze the scope of Article 51 of the United Nations Charter. I also wish to thank the briefer, Professor Modir-Sadeh, and acknowledge Mexico's leadership on this regard. This discussion is even more relevant for Ecuador as we continue commemorating the 75 years of the Charter, and considering that our former president, Camilo Ponce Enriquez, co-chaired the committee responsible for the drafting of Chapter 7 from Articles 39 to 51. Of course, it is important that we consider and discuss the implementation that has been given to different provisions of the Charter against non-state actors, in particular in the context of counterterrorism. It is also important for my delegation not to reinterpret any provision of the Charter. The right of individual and collective self-defense exists, and for its exercise, it shall be immediately reported to the Security Council. I wish to reiterate the full commitment of Ecuador on the fight against terrorism. As I stated on the Security Council open debate held on 12 January 2021, in light of the resolution 1373, adopted by the Security Council 20 years ago, we must continue to strengthen our global efforts to prevent and counter terrorism. For this, it is essential to also address the causes and factors that facilitate acts of terrorism, including its financing as well as political, ethnic, and religious intolerance, among others. At the same time, I wish to reiterate my delegation's concern about the increase in the number of letters addressed to the President of the Security Council under Article 51 of the Charter, with regards to military actions in the context of the fight against terrorism. Ecuador, as a member of the Community of Latin American and Caribbean States, CELAC, has also expressed its concerns due to the fact that most letters under Article 51, in order to have recourse to the use of force in the context of counterterrorism, were submitted to the Security Council ex post facto. We need to guarantee that action is taken in compliance with all the obligations established in the Charter. Nothing justifies limiting the principles of transparency, accessibility, and information for every member state, including those that are not occupying a seat in the Security Council. Efforts to close the existing gaps of information in the repertoire of the practice of the Security Council should be supported. Ecuador further calls on the Security Council to improve the means by which the report are made available and facilitated with access to member states on a timely manner. I wish to recall that as principle, Ecuador values all subjects put forward by the member states for discussion. In this vein, Ecuador supports a comprehensive approach and greater synergies by all United Nations organs for any element related to the peace and security. At the Special Committee on the Charter of the United Nations on the strengthening of the role of the organization, we confirmed our support for the exchange of views on the limits of the use of military force in the fight against terrorism, in full compliance with the provisions established by the UN Charter. Finally, the best way to implement the United Nations Charter is by ensuring a world free of violence, and for that purpose, we need to strengthen the United Nations efforts on the international peace and security. On this regard, I wish to reiterate once again the need for the Security Council to establish a mechanism to facilitate the implementation of Resolution 2532, in particular on the global ceasefire, which could be a first step for a permanent peace in many places. Thank you very much.
Gracias, Christian, por tu contribución. And now I'll give the floor to the PR of Pakistan. Munir, the floor is yours.
And thank you for organizing this very valuable discussion on the scope of the use of force in international law. 70 years ago, the peoples of the world came together to save succeeding generations from the scourge of war. They undertook in Article 2.4 of the UN Charter to refrain from the threat or use of force against the territorial integrity and political independence of sovereign states. The framers of the Charter provided only two exceptions to the prohibition on the use of force. First, enforcement measures taken or authorized by the Security Council acting under Chapter 7 of the Charter, and second, under Article 51 in the exercise of the right of individual or collective self-defense. Such use of force in self-defense is also strictly governed by the twin conditions of necessity and proportionality, and authorized only until the Security Council has taken measures necessary to maintain and restore international peace and security. The purpose clearly was to outlaw the resort to force. Unfortunately, today, the resort to unauthorized and unilateral use of force is most visible in several situations: in foreign occupation and intervention, in denial of the right of self-determination, in the coercion of smaller and weaker states. Pakistan faces cross-border terrorist groups from attacking our soldiers and civilians from the territory of a neighboring state sponsored by a third state. Pakistan has respected the territorial integrity and sovereignty of its neighboring state, but we have the right of self-defense against the state which is sponsoring these terrorist attacks against Pakistan. It is also regrettable that after 9/11, the fight against international terrorism has been utilized to justify the unilateral use of force and foreign intervention. The use of force in self-defense is limited to repelling an armed attack. It does not cover future or anticipated attacks. The concept of preventive or anticipatory use of force is contrary to the UN Charter and is illegal. The struggle of peoples for self-determination cannot be equated with terrorism. Peoples whose right to self-determination has been recognized and which is being forcibly suppressed have the right under the Charter and the resolutions of the UN General Assembly to resort to all possible means, including armed struggle, to secure their right to self-determination. They also have the right to receive moral and material support for their legitimate struggle for self-determination. In our region, we have been subjected to some of the worst manifestations of such violations of the UN Charter and the resort to aggression and the use of force and the threat of use of force. One clear example is the illegal military occupation by India of the state of Jammu and Kashmir. Its use and threat of use of force against Pakistan and other neighbors, and its resort to state terrorism as an instrument of policy to coerce neighbors and oppress the people of Jammu and Kashmir. The attacks in Pulwama and Pathankot were conducted by Kashmiris responding to India's brutal suppression of their struggle for self-determination. In February 2019, India's military adventurism almost triggered another war with Pakistan. A catastrophe was avoided due to the restraints exercised by Pakistan. Recent leaks in the Indian media have revealed hyper-nationalist base and to improve their electoral prospects. Distinguished colleagues, the world has avoided another global conflict for 75 years. But if some states continue to undermine the fundamental principles of the Charter, the world could once again be engulfed by conflicts that could put humanity's very existence at risk. I thank you for this opportunity to convey our viewpoint. Thank you, Joanna Ramon.
Thank you, Munir. I would kindly remind you to please try to stick to the allocated time so that we have an opportunity to listen to all the participants. I will now give the floor to the PR of Iran. Majid, you have the floor.
Juan Ramon, thank you very much. I don't know why my video does not work, but anyway, I will read my statement. Thank you, Mr. Chairman. Thank you for organizing this meeting. I want to also thank Professor Modirzadeh for her remarks. I will make a few brief points on the agenda of today's meeting. First, prohibition of the threat or use of force, save the two exceptional cases authorized by the Charter, is one of the greatest accomplishments of our organization. This is a cardinal principle of international law, the preservation and full observance of which is our collective responsibility that must be fulfilled responsibly. Second, states have intrinsically an obligation to protect their citizens and territories, and accordingly enjoy an inherent right to self-defense. The term inherent clearly and adequately reflects the national foundations and essential importance of this right, which of course must be exercised only, quote, if an armed attack occurs, end of quote. These are the well-drafted and well-crafted terms of the Charter. Obviously, it must also meet the criteria of necessity, proportionality, and immediacy. Third, there is, however, a growing tendency by some states to resort to the threat or use of force through abusing the inherent right to self-defense. For instance, when the United States forces, at the direct order of the US president, brutally assassinated Martyr Soleimani in Iraq, in gross violation of the basic norms and principles of international law, the US government, through its communication to the Security Council president, attempted to justify such an obvious act of terrorism through a series of fabrications and extremely arbitrary interpretation of the Charter's Article 51. Many international law scholars and practitioners have categorically rejected such an interpretation on the right to self-defense. Fourth, this alarming trend must be a source of serious concern to all states, and every effort must be made to reverse this extremely dangerous process. If unchecked, the right to self-defense will not only be abused more frequently by such states, but also they will institute further exceptions to the principle of the prohibition of the threat or use of force. Fifth, measures taken in self-defense shall be reported to the Council immediately. Reporting is therefore obligatory and should naturally include the main elements of the measures that the country concerned determines necessary, which might be different from one case to another. It is obvious that Article 51 has not obligated the states to observe a specific requirements in their reporting, and therefore has left the decision to the discretion of reporting states. Last but not least, to prevent the progressive erosion of the principle of prohibition of the threat or use of force, any reinterpretation or arbitrary interpretation of Article 24 and 51 of the Charter must be avoided. This is necessary for the common good. I thank you, Mr. Chairman.
Thank you, Majid. While we were not able to see you, we heard you loud and clearly. And now I give the floor to the PR of Armenia. Mayor, the floor is yours.
Thank you, Juan Ramon. I would like first to thank the delegation of Mexico for organizing this Arria Formula meeting on upholding the collective security system of the UN Charter, as well as Professor Modirzadeh of Harvard Law School Program on International Law and Armed Conflict for her very informative briefing. We appreciate Mexico's efforts to promote dialogue on this important topic, also in the framework of the Special Committee on the Charter, through submission of the working paper on analysis of the application of Articles 2 and 51 of the Charter of the United Nations. In discussing the scope of the right to self-defense, an essential point of reference is the framework of the UN Charter, as Article 2 clearly stipulates inadmissibility of threat or use of force in any manner inconsistent with the purposes of the United Nations. The issue of invocation of Article 51 needs to be addressed in the context of obligations arising from the peremptory norms of general international law, such as the right to self-determination, prohibition of genocide and crimes against humanity. In a world where conflicts and disputes in their various forms regrettably continue to persist, prohibition of the use of force and strict adherence to peaceful settlement of disputes are indispensable to the maintenance of international peace and security. Nothing in the UN Charter or the general international law can justify instances of instrumentalization of the concept and practice of self-defense as a cover-up for military action in an effort to resolve an international dispute by force. In this regard, and to put the issue into context, I want to bring to your attention the premeditated armed aggression of Azerbaijan against the people of Nagorno-Karabakh, unleashed in September 2020, which comes as a dangerous precedent of violating the preeminent obligation to strictly adhere to the principles of non-use of force or threat of force, and the pacific settlement of disputes by opting instead for instigation of violence, conflict, atrocity crimes, and involving terrorist fighters. A country that over the years has been consistently rejecting the peace process and the proposals for the settlement of the conflict put forward by the mediators has launched the biggest military escalation in times of the COVID-19 pandemic with direct and unrestricted military support of another country, Turkey, and the involvement of thousands of foreign terrorist fighters and mercenaries from the Middle East. Given the nature and scope of Azerbaijan's violent conduct, resulting in the loss of thousands of lives and widespread destruction in the midst of a global health crisis, it is clear that such actions have been aimed not at defense, but at an intentional infliction of maximum casualties on Armenian side. Such actions have in fact demonstrated that not only this country was not acting in self-defense, but also that it had no intention of complying with the purposes and principles of the UN Charter. This was further evidenced by its failure to adhere in good faith to the trilateral statement on the establishment of ceasefire in the area of Nagorno-Karabakh conflict, which stipulates, among other provisions, for immediate release of prisoners of war and other detained persons. To this date, this key provision remains unimplemented by Azerbaijan despite the calls of the international community, including the UN human rights experts, who have appealed for the prompt release of all prisoners of war and other captives from Nagorno-Karabakh conflict. On a final note, Mr. President, I want to emphasize the importance of the efficient utilization of the prevention toolbox of the United Nations and regional organizations for timely identifying of and adequately responding to the warning signs of gross violations of humanitarian law and human rights law, which, if not addressed properly, can lead to serious threats to the international peace and security. And I thank you.
Thank you for your remarks, and I give the floor to the PR of Qatar. Alia, the floor is yours.
Thank you very much, Mr. Chairman. At the outset, I would like, of course, to express our appreciation to Mexico for taking the initiative to convene this Arria formal meeting. And we also would like to thank Professor Naz Moderzadeh, Director of the Harvard Law School Program on International Law and Armed Conflict, for her statement. Mr. Chairman, Qatar is well known to emphasize many of the principles that have come up repeatedly in today's discussion, including first and foremost, that all member states should uphold their obligations in accordance with the United Nations Charter and should refrain in their international relations from the use of force in a manner inconsistent with the purposes of the United Nations. In its commitment to contribute to efforts to achieve peace, security, stability, and development in our region and around the world, the State of Qatar proceeds from the recognition that peaceful means are the best means to achieve these goals. At the same time, one must recognize that certain situations necessitate the use of force, notably in the application of the inherent and legitimate right to self-defense, and to counter the serious threats posed by terrorist acts. There is indeed consensus that terrorist acts do pose serious threats to peace and security and have caused grave human suffering and social and economic impacts. Therefore, many member states, including the State of Qatar, as a responsible member of the international community, has taken part in the collective action to fight common threats posed by UN designate terrorist groups, including firm and decisive actions as necessary. But again, we must reiterate here that, as a matter of principle, the use of force should only be the last resort. It is worth re-emphasizing that the right to act in accordance with the privileges afforded by certain charter provisions does not absolve one from the obligations per other provisions. Indeed, international law, international humanitarian law, and international human rights law are always applicable and must be respected. Finally, Mr. Chairman, in matters involving regional and international peace and security, we should remember that the primary role of the Security Council in accordance with the Charter. This role needs to be undertaken in a responsible manner and strictly in accordance with the relevant provisions of the Charter. In this respect, initiatives such as the meeting today, which highlights the primary of the Charter and commitments to its principles, are welcomed and encouraged. And I thank you again.
I thank you for your remarks, and I'll give the floor now to the PR of Cambodia. Sovan Ke, the floor is yours. I then will move to the next on the list, who is the PR of Denmark. Martin, the floor is yours now.
Thank you, Juan Ramon. Excellencies, members of the Security Council, allow me firstly to thank Mexico and you, Juan Ramon, for convening this meeting and providing the opportunity to have a debate on such a significant topic. I would also like to thank Professor Naz Modirzadeh for her briefing, which provides a useful introduction. Mr. Chair, let me just try and see if I can turn this other thing down. Hang on.
Sven, the EU has been very forceful in condemning the...
Sorry about that. The maintenance of international peace and security lies at the core of the UN Charter. Now, Denmark is a strong proponent of a rules-based international order and multilateral cooperation based on international law, coherence, and transparency. In our view, reports to the Security Council under Article 51 of the UN Charter are both important and useful. While there is no automaticity in the Security Council addressing these reports, they are a means to help ensure that the Security Council may speedily take such action as it deems necessary in order to maintain or restore international peace and security. That said, lack of action by the Council following receipt of an Article 51 report should not be seen as an endorsement or acceptance of the legality of that particular act of purported self-defense. The reports, furthermore, create a public record which allows the international community to understand and engage with the position of states exercising their rights of self-defense. Mr. Chair, notwithstanding the importance of Article 51 reports, we would note that Denmark does not consider such reports as a precondition for legality of an act in self-defense. The requirement is procedural rather than substantive. A state's failure to report measures of self-defense to the Security Council shall not in itself affect the legality of the Self-Defense Act in question. That being said, the requirement to submit a report under Article 51 must be taken seriously and complied with at all times. As noted in the concept note for this meeting, we agree that transparency and accessibility of these reports are of importance. In our view, current practice of publication provides a sufficient basis for most stakeholders. But we have noted with interest the various proposals and share the view that there may be room for improving easy access. We look forward to further debate on such initiatives that increase transparency and accessibility to state practice. As to recent practice of Denmark, Mr. Chair, allow me to mention our letter under Article 51 to the Security Council dated 11 January 2016. In this letter, it was reported to the Council that Denmark, with reference to Resolution 2249 in 2015, and as a response to the request by the Iraqi government, was taking necessary and proportionate measures against ISIL in Syria in exercise of the inherent right of collective self-defense of Iraq. Said practice was in agreement with and has later been confirmed by several delegations. Mr. Chair, the concept note for this area formula meeting reflects on the gravity of terrorist acts, their high humanitarian, political, and social cost, and the threat they pose to international peace and security. It also notes differing approaches among states to certain legal aspects of the fight against terrorism and to Article 51 specifically. As we have heard in today's debate, these differing approaches persist, which only underscores the usefulness of further discussion. Thank you, Mr. Chair.
Thank you.
And apologies for the disturbance.
Thank you very much for your remarks, and I will give the floor now to the delegation of Peru.
Thank you, Mr. President. I would like to congratulate the Permanent Mission of Mexico on convening this important meeting, and to thank Professor Modirzadeh for her briefing, which allow us to exchange views about the use of force in international law, particularly in accordance with Article 51 of the UN Charter. This subject matter was addressed during the fourth informal meeting of Latin American legal advisors on public international law, organized by Peru here in New York in October 2018. In this respect, allow me to briefly share with you the national perspective of Peru regarding the use of force, which was also put forward by my delegation during our recent membership in this Security Council. The most fundamental of all obligations under present international law derives from the principle of the non-use of force. In 1988, Ambassador Javier Pérez de Cuellar pointed out that the commitment assumed by the states in Article 2 of the United Nations Charter to resolve their dispute by peaceful means and not to resort to the threat or use of force unequivocally consecrate the principle of the illegality of the war of aggression. Likewise, he stressed that the acceptance of this principle confers on the Charter its unique character in the history of public international law. The Charter establishes two exceptions to the general rule of the non-use of force. First, forcible measures may be taken or authorized by Security Council pursuant to Chapter 7 of the Charter. Second, force may be used in the exercise of the right of individual or collective self-defense as acknowledged in Article 51. Nowadays, there is serious concern to respond adequately to modern security threats, such as terrorism or the proliferation of weapons of mass destruction. In relation to counterterrorism, we are aware that in recent years, the right to self-defense has been invoked to justify the use of force in the territory of another state. We deem that any use of force needs to be exercised in accordance with the Charter of the United Nations and international law. Furthermore, with regards to procedural issues and transparency, we believe that communication to the Security Council under Article 51 justifying certain actions in the fight against terrorism must be published and brought to the attention of the larger membership. Otherwise, there might be a risk of distorting the restrictive meaning that should be given to self-defense. Peru is convinced that in order to maintain international peace and security, it is important to take actions for the proper consideration of this issue within the organization, including in the Security Council. A significant and permanent global effort is needed to strengthen the collective security system. You may count with my delegation in that endeavor. I thank you very much, Mr. President.
Muchas gracias, Luis, por tu participación. And now I'll give the floor to the delegation of Syria.
Thank you, Excellency, for organizing this important meeting. And I also thank Professor Modizada for her briefing. I would like to point out that sparing humanity from the scourge of war was the supreme goal of the United Nations. However, this goal collided, unfortunately, with the stance of some member states who prioritized their narrow interests and ambitions at the expense of the values of laws, justice, and the suffering of the peoples of many other member states, including my country, Syria. Unfortunately, this government have attempted to cover up their aggressive acts and their gross violations of the principles of international law, international humanitarian law, human rights instruments, and the provision of the Charter by seeking to distort the Charter and tamper with its provisions. And this is what we witnessed when they formed the illegal and illegitimate so-called international coalition under the pretext of combating ISIS based on Article 51 of the Charter, without fulfilling the requirement stated in the text of this article and without obtaining the approval of the Security Council or the consent of the Syrian government, and also without coordination with the concerned party, which is the Syrian government. We informed the Security Council of our position in several official letters, and we called for the establishment for a legitimate coalition to combat terrorism under the umbrella of the United Nations. But some Western permanent members in the Security Council opposed that. The result was that the illegitimate US-led coalition destroyed the Syrian city of Raqqa, killed thousands of its residents. They attacked the Syrian army and set the stage for the American occupation of parts of the northeast of my country. The Turkish regime has also taken a similar approach, using the pretext of legitimate defense and Article 51 to launch aggressive actions against my country, support terrorism, and occupy parts of the Syrian territory in north and northwest Syria. My delegation stresses the need to put an end to all attempts to misuse the provision of the Charter and distort interpretation of Article 51 by some member states. We call for the upholding of the principles of international law and the provisions of the Charter that represent the common denominator between us. And we support a genuine and objective dialogue on this topic. I thank you, Mr. Chairman.
Thank you for your remarks, and I give the floor now to the PR of Austria. Axel, the floor is yours.
Gracias, gracias, Juan Ramon. And it's great to have a discussion like this on a core question of international law in this format. I think that's an excellent idea. So let me thank Mexico for convening this meeting and also thank Professor Modirzadeh for her excellent briefing setting the stage. Austria shares the concern of others about the increasing number of cases where armed force is applied unilaterally while invoking the right of self-defense pursuant to Article 51 of the UN Charter. Considering that the principle of the non-use of force is if not the core principle of the UN Charter, this discussion today merits continued attention also beyond this meeting. Professor Modirzadeh gave us 3 questions, and I'm going to try to address them, but only in a very preliminary way, again, hoping that there will be more opportunity to continue the discussion in more depth. And I'm going to start with the second question that you posed, not only to make things interesting, but also because I believe it is the most important. What are the legal effects of the multitude of communications pursuant to Article 51? I think you pointed out over 400. And how should we understand the silence of states in reaction to the communications? Now, Austria's view on this here is very clear. We believe that all the instances of communications pursuant to Article 51 and the lack of action by the Security Council following the receipt of these communications and the fact that other UN member states do not formally react and publicly express their legal views on each and every case may not be interpreted as an expression of a new state practice or opinio juris that might lead to the erosion of Article 2, Para 4 of the UN Charter, which the ILC has determined to be a peremptory norm of international law. To be legally significant, the silence in cases affecting jus cogens would have to be unequivocally intentioned to actually have legal significance and not just simply occur. In our view, the current practice neither amounts to instances of the maxim qui tacet consentire videtur, that by staying silent, states acquiesce to the legality of the underlying action, nor does it enable a change of the legal norms regulating the right to self-defense by virtue of subsequent practice of the member states. We heard quite a few comments on one aspect of the substantive law, the question of legality of invoking Article 51 in response to an attack by non-state actors. According to the prevailing view shared by Austria, also acts of non-state actors can amount to an armed attack in the sense of Article 51, provided that 2 conditions are fulfilled. First, there is a transboundary element. For example, the non-state actor operates from the territory of another state. And second, the other state harbors or otherwise substantially supports the operations of the non-state actor on its territory or is unable to prevent or suppress such operations as a consequence of the complete absence of state authority and effective control over the respective territory. Finally, on procedure, we agree that it would be beneficial if there was more clarity. Article 51 of the UN Charter obliges all member states to immediately communicate to the Security Council the measures taken in the exercise of their right of self-defense. These reports should not only describe the measures taken, but should also contain all relevant information about the factual background in order to enable the Security Council to assess whether the legal requirements for the exercise of the right of self-defense, such as necessity, imminence, and proportionality, are actually met. The immediacy of the communications under Article 51 must be such as to enable the Security Council to make a swift assessment and to exercise its authority and responsibility under the Charter to take an action in order to maintain or restore international peace and security. The Article 51 report should thus be a matter of hours, not days or weeks. Given the importance of these instances for all member states, it would be desirable and necessary for the Security Council to discuss, examine, and consider reports submitted under Article 51 on a regular basis. Finally, let me stress that Austria supports all efforts to improve transparency and publicity of the reports. We would very much welcome swift distribution to all member states as documents of the Security Council as soon as they are received, as well as online accessibility of the reports, as well as of any reactions to the communications in a consolidated and systematic manner, in addition to their publication in the annual reports on the activities of the Security Council. Thank you, and thanks and congratulations once again, Juan Ramon. Such an interesting discussion. Good to see you. Bye.
I thank Austria for the remarks, and I'll give the floor now to the PR of Sri Lanka. Mohan, the floor is yours. Can you hear me? Mohan, can you hear me?
Can you hear me? Yes, of course. Thank you. Thank you, Mr. Chairman. We thank the Permanent Mission of Mexico for organizing this timely event to look at the issues of upholding collective security under the United Nations Charter and the issue of the use of force in international law, non-state actors, and self-defense. When the founders of the UN pledged to save succeeding generations, Mr. Chairman, from the scourge of war, emerging from the ravages of 2 world wars and a historical past where differences between states were often settled by war, the Charter is notable for expressly prohibiting the use of war as an instrument of state policy and affirmed the selective applicability of those principles, affirmed the primacy of prevention and peaceful settlement of disputes. Now, the universal and non-selective applicability of those principles are clearly evident in Article 2 of our Charter. Now, this principle has been given much importance that it has found a place across the road from the United Nations, as such importance has found a place, as I said, across the road from the United Nations, where a monument stands with an inscription from Isaiah, which says, "They shall beat their swords into plowshares and their spears to pruning hooks. Nations shall not lift up sword against nation, neither shall they learn war anymore." Now, one would wonder if this was only meant to be a nice phrase or what we really wish to live by those pledges, as the world appears to be in a state of absolute chaos. Now, an ongoing example of this wisdom of Isaiah, perhaps in current times, is the need for the dismantling of nuclear weapons and the use of their components as fuel in civilian electric power stations, the megaton to megawatts program. The nuclear fission development used in World War II has now been used to generate electricity and radiopharmaceutical production. Now, what kind of force, I ask, then is within the concept of the jus ad bellum? This argument appears to be that there exists a gravity threshold below of which the prohibition of the use of force is inapplicable. Put differently, the prohibition of the use of force covers all physical force which surpasses the minimum threshold levels of intensity. In other words, a small incident to be brought under control must be responded to with correspondingly small measures. An example would be the neutralization of a single individual with force that is not commensurate with that particular act of neutralization, or the example of the abduction of persons forcibly, or perhaps the interception of a small vessel at sea by a warship. Now, there are numerous acts that can be classified as encounters between military units. It would therefore appear that to exclude small-scale or targeted acts from the ambit of Article 2.4 is a moot point, as it appears to be inconsistent with customary practice and cannot be recommended as a matter of policy. It is clear that Article 2.4 enjoins all members from the threat or use of force against the territorial integrity or political independence of any state or in any manner inconsistent with the purposes of the United Nations. So in the emerging multipolar world, what we are experiencing, Mr. Chairman, is that it is necessary to re-examine the inadmissibility of the use of force outside the Charter provisions and without proper authorization by the Security Council. There is also a need to ensure that where there are cases of the use of force authorized, it should be employed responsibly with action that should be judicious, proportionate, and strictly limited to the objectives of the mandate and in line with the international humanitarian law in view of the emerging threats to international peace and security. There are two generally accepted exceptions to the prohibition of the use of force under international law, as we all know. The use of force authorized by the Council, where there exists a threat to the peace, breach of peace, or an act of aggression, and the inherent right to self-defense of sovereign states under Article 51 and customary international law. However, we remain concerned about the increasing number of instances where the use of force has been applied unilaterally, invoking a right of self-defense pursuant to Article 51 of the Charter against non-state actors in other territories. These exceptional cases should not be considered as a new norm or evidence of state practice. It must be highlighted that the Charter includes sufficient provisions regarding the use of force that should be done strictly in conformity with the relevant Charter provisions. The use of force in self-defense against terrorist groups is one of the most controversial issues in the field of the jus contra bellum today. It may be noted that in several instances, the application of Article 51 has been limited, and that the ICJ has also pronounced upon this recently and has said that it is restrictive and should not be rewritten or reinterpreted. There has been an increase in Article 51 cases being invoked against non-state actors. It may, however, be noted that Article 51, as well as the ICJ advisory opinion on the legal consequences of the construction of the separation wall, made it clear that attacks on non-state actors that gives the right of self-defense must come from states and not from state actors. So finally, the peaceful settlement of disputes and the prevention of conflicts must remain key aspects in the work of the UN to strengthen regional and international peace and security. The United Nations may further promote and assist states in utilizing applicable means specified in Article 33 of the Charter for the settlement of disputes. The outer parameters of the notion of self-defense has been increasingly pushed as to what constitutes an armed attack and by whom, and what is meant by imminence, necessity, or proportionality. It would therefore appear that the breadth of the right of self-defense remains rather unsettled and presently driven by political or legal considerations. Some parties want a rather elastic interpretation, while others make out a case for the liberalization of the use of force. Now, the argument may well culminate in the right of self-defense being interpreted to strengthen the prohibition of war and enhance human security. It seems to be suggested that it is better to interpret the state as a collectivity of individual human beings, and upon this hypothesis, an armed attack to be reconceptualized as a serious violation of human rights. It is not difficult to therefore appreciate that the response to such an attack then raises similar questions as in the case of humanitarian intervention. It has been a moot point amongst academia that there is a desirability of a draft declaratory resolution on self-defense in the light of the uncertainties surrounding the scope of self-defense. One such attempt was the principles governing self-defense against non-state actors, which was known as the Bethlehem Principle, which recognizes the need to bridge the gap between academic discourse and the operational needs of state and to bring some clarity and precision to when state actors may use force in the territory of another state against armed attacks by non-state actors. To conclude, it is observed that the very concept of the right of self-defense has been called into question in the context of a blurring of the differences, as one academic puts it, between what is external and what is internal, together with the growing consciousness of belonging to one human family. Human security, Mr. Chairman, is about the security of individuals, in protecting individuals. Therefore, the lives of other individuals also must be taken into consideration. The use of force, therefore, must be sustainably managed. It is therefore a critical question for us to consider, or worthy of consideration by this assembly, as to whether there can be a difference between a war approach and a human rights approach. Thank you.
Thank you, and I will give the floor now to the PR of Finland. Jukka, the floor is yours.
Thank you so much, Juan Ramon, and Finland would like to thank Mexico for its continued efforts to bring to discussion pertinent questions relating to the United Nations Charter. Initiatives of this kind are welcome contributions to the continued validity and relevance of the collective security system of the UN Charter and how it is supposed to work. We are pleased with the inclusive format of this discussion and the opportunity to offer a few remarks. Last time we had the occasion to speak at this forum was in December, when the Nordic countries took part in the debate relating to the cooperation between Security Council and the International Court of Justice. Finland welcomes opportunities to reflect on the functioning and cooperation between the main bodies of the UN in the fulfillment of their charter-based mandates. We would also like to thank Professor Modirzadeh for her useful insights. Finland is a strong proponent of a rules-based international order and multilateral cooperation based on international law. We are committed to the UN Charter and its collective security system. Regarding the questions outlined in the concept note, we believe that there is a need to discuss how to accommodate extraterritorial responses to terrorism with the use of force regime of the UN Charter. We continue to hold the view that any measures against terrorism must be in accordance with international law, including international humanitarian law, refugee law, and human rights law. The need to discuss how the existing framework of international law applies in modern contexts, such as in the cyber realm and outer space, has also been recognized, and efforts to find common ground are ongoing in the General Assembly. The significance of the Article 51 reports for the use of force regime of the UN Charter cannot be overestimated. Importantly, the reports also help to increase understanding of the positions of the states involved in the relevant operations. Finland supports efforts to enhance the transparency and accessibility of these reports. Thank you.
Thank you very much, Jukka, for your contribution. And I will now give the floor to the delegation of Turkey.
Thank you, Ambassador. And we thank Professor Modirzadeh for her briefing as well. Article 51 of the UN Charter, which embodies the inherent right of self-defense, clearly stipulates to whom this right belongs, while not using restrictive language as to the actor against which this right may need to be exercised. This actor can indeed be, and increasingly is, a terrorist organization. Any other interpretation of this article would be contrary to the notion of self-defense. Furthermore, the recognition of the inherent nature of this right rooted in customary international law, the pronouncement that nothing in the Charter shall impair this right, and the fact that the article does not attempt to regulate this concept in detail reinforce the very particular nature of self-defense. The foregoing aside, it is all too clear that terrorism constitutes one of the most serious threats to international peace and security in the 21st century. Terrorist organizations carry out heinous attacks and inflict serious harm beyond the borders of nation states. In most cases, this is done without the consent, support, or involvement by the state from whose territory they launch their terrorist activities. This brings us to the concept of sovereignty, and the responsibilities and obligations that it entails, as reflected in the letter and spirit of the UN Charter. Sovereignty is linked inseparably to its effective and due exercise. However, unfortunately, this is not always the case in practice. Indeed, we have very frequently been seeing instances in which states are not capable or willing to prevent terrorist organizations from controlling parts of their territories and using them as safe havens to carry out terrorist attacks against neighboring states and other states. From a broader perspective, the issue of failed states poses a major challenge. As a matter of fact, these countries fail to exercise their sovereignty and accordingly cannot discharge their legal responsibilities, first and foremost, towards their neighbors. In this context, the responsibilities attributed to states by Security Council resolutions 1368, 1373, 1624, 2170, and 2249, among others, must be taken into consideration. The first two of these resolutions clearly reaffirmed the inherent right of self-defense in the face of international terrorism. In other words, terrorism that crosses international borders, with overwhelming support by the international community. Further, in the past few decades, states from various regions of the world have exercised this right against the threats posed and violent crimes launched by terrorist organizations. Some of these cases indeed concerned the lack of necessary action by the state on whose territory the relevant terrorist organizations operated. Having stated the above, there is no doubt that the principles of necessity and proportionality should be observed and all applicable rules of international law respected in the exercise of the inherent right of self-defense. We consider the term immediacy in Article 51 to be clear, bearing in mind that the reporting requirement is not a condition on the lawfulness of the exercise of self-defense. Transparency in the work of the UN, on the other hand, should be tackled holistically and in a non-arbitrary manner. Finally, we advise caution against an unduly restrictive interpretation of Article 51 that would hamper states' fundamental right and responsibility to protect their territory and nationals against actual or imminent attacks by terrorist organizations. As we saw with Daesh and Al-Qaeda, this problem has become one that knows no boundaries and that can very quickly come and knock on our door. Therefore, such a restrictive approach as to the scope of the inherent right of self-defense would also undermine the existential fight against international terrorism, which we have decided to undertake as the global community. Turkey remains strongly committed to work towards ensuring that we can address the contemporary global challenges in an effective, collective, and non-discriminatory manner while preserving the integrity of the UN Charter. Mr. Ambassador, I am obliged to express our regret that this meeting, which aimed to have a non-political discussion of the topic in question, was disrupted by ill-intentioned attempts to make accusations and baseless allegations against my country, which we reject. Turkey has expressed in a loud and clear manner that it is fully committed to the principles of territorial integrity and unity of states in its exercise of the inherent right of self-defense against the direct and imminent threats posed by terrorist organizations from across its borders. The measures taken in this regard are in strict adherence to these principles, as well as to the principles of necessity and proportionality, targeting only the terrorists and their hideouts, weapons, and equipment. We also categorically reject the allegations of the delegation of Armenia, which contains similar elements of smear campaign used by that delegation in previous months. Instead of misusing every platform of the UN, we advise Armenia to focus on fulfilling its obligations under international law, which it blatantly violated for 3 decades, including by its illegal occupation of Azerbaijani territories. I thank you.
Thank you, Turkey, for your remarks. The floor is for the delegation of Togo. The delegation of Togo. No? If not, then I will move to the delegation of Brazil. Brazil, por favor.
Mr. President, I thank the permanent mission of Mexico for organizing this meeting. And I thank Professor Modizarde for her excellent briefing. Brazil welcomes the topic chosen for this Arria formula meeting. The prohibition to the use of force is a cornerstone of contemporary international law and a source of stability. It is a peremptory norm to which only 2 exceptions are permitted. self-defense, and authorization under Chapter 7. The world has witnessed the devastating consequences of abuses to those exceptions. Throughout the years, armed conflicts were initiated on the basis of uncertain facts and questionable interpretations of applicable law. Uncertainty in this realm may lead to modern violations of international law. It might escalate conflicts and generate serious humanitarian consequences. Hence, as a matter of law and of policy, exceptions to Article 2(4) of the UN Charter must be interpreted restrictively. The right to self-defense, in particular, has clearly defined boundaries established in Article 51 of the Charter. It must be read in line with Article 2(4) so as not to undermine it. Since Article 2(4) does not mention states, Article 51 must be interpreted in that light. The right to self-defense is only triggered by an armed attack undertook by or somehow attributable to a state. It's not possible to invoke self-defense as a response to acts by non-state actors. This view is in line with the case law of the International Court of Justice, which has made it clear that territorial state would have to be sending or have substantial involvement in the acts of non-state actor for the conditions for self-defense to arise. The court has repeatedly indicated that self-defense is a right that only applies between states on the international plane. Non-state actors are not located in a vacuum. They are located in a territory of a state whose sovereignty must be respected. States do not have an obligation not to allow knowingly its territory to be used for acts contrary to the rights of other states. If that happens, international law provides avenues to address the matter. Resort to force is generally not one of them. In conclusion, Mr. President, due to the fundamental importance of the prohibition to the use of force to the international community, all countries have a stake on the issue, hence the importance of transparency. Brazil calls on this Council to promptly make public the report submitted to it under Article 51 of the Charter. Being the primary guardian of the international peace and security, this Council should act in a transparent manner as a steadfast defender of the integrity of the norms that form our collective security system, as the full respect of international law is the only way to achieve peace and sustain it. Thank you very much.
Thank you, Ambassador de Almeida, for your remarks. The floor is now for the delegation of Azerbaijan, please.
Thank you, Ambassador, and thank you, Professor Modirzadeh, for your presentation. The Charter of the United Nations addresses the prohibition of the use of force in Article 2, Paragraph 4, in terms of interstate force. As one of the two exceptions to this prohibition, the exercise of the right of self-defense is permitted in Article 51 of the Charter in response to an armed attack. Undeniably, invasion or attacks by the armed forces of a foreign state, military occupation, and bombardment, the highlights of the 1974 definition of aggression, including in indirect ways by the use of subordinate irregular forces, constitute armed attacks triggering the right of self-defense in accordance with Article 51 and customary international law. Article 51, in laying the ground for the right of self-defense, mentions a state only as the potential target of an armed attack. At the same time, the perpetrator of that armed attack is not identified necessarily as a state. By implication, an armed attack can be therefore carried out by non-state actors, including terrorist groups. It is for every state to judge for itself in the first instance whether a case of necessity in self-defense has arisen. The acting state is one to determine when, where, and how to employ counter force in response to an armed attack. Article 51 requires that the self-defense measures be reported immediately to the Security Council. The Council may adopt a binding decision, either endorsing the invocation of self-defense or rejecting it. Alternatively, the Council may do nothing, either by choice or by force of a political reality. A third option is the adoption by the Council of a non-binding recommendation as to what it thinks should be done. Basically, it is for the state acting in self-defense to evaluate whether the Council's efforts have been crowned with success. Short of an explicit decision by the Council to desist from any further use of force, the state acting in self-defense retains its right to proceed with the forcible measures that it has chosen to pursue in response to the armed attack. The duration of the right of self-defense is determined by the armed attack and its continuous effects, such as, for example, prolonged occupation. Mr. Ambassador, yet in 1993, the Security Council adopted 4 resolutions condemning the use of force against Azerbaijan and the bombardment and occupation of its territories, and reaffirming respect for the sovereignty and territorial integrity of my country, the inviolability of international borders, and the inadmissibility of the use of force for the acquisition of territory. Our arguments rest on the foundation that the attacks against Azerbaijan are imputable to a foreign state, namely that they are attributed to Armenia, which has deliberately disregarded the demands of the Security Council, has never engaged faithfully in negotiations, and instead directed all its efforts at colonizing the seized territories under the cover of ceasefire and peace process. As a result of the counter-offensive operation undertaken and successfully accomplished by the armed forces of Azerbaijan in the exercise of the right of self-defense, the territories of Azerbaijan were liberated from occupation. The enemy's military capability in those territories was destroyed, and Armenia was enforced to peace. The end of aggression and occupation has become a triumph of justice and international law, and underlined again the necessity of strict compliance by states with their international obligations. I thank you.
And I thank Azerbaijan and I give the floor to the Netherlands.
Thank you, Mr. Chair. Thank you, Professor. Thank you, Mexico, for convening this Arria formula meeting and the opportunity to have an exchange on the scope of Article 51, a crucial provision in the UN Charter. And Mr. President, at the outset, the Kingdom of the Netherlands believes that as an exception to the prohibition on the use of force, the right of self-defense must not be interpreted too broadly. At the same time, the very nature of self-defense requires that it is able to deal with contemporary threats. When assessing self-defense as the legal basis for the use of force, in our view, a few topics are important to note, and I'll note 4 in total. First of all, it is important to establish the existence of an armed attack or an imminent armed attack. The use of force must have a certain scale and effects in order to constitute an armed attack. It must consist of more than isolated incidents, terrorist or not. The Netherlands considered it important to stress that an armed attack can also be carried out by an organized armed group, such as the terrorist group ISIL. Thus, in our view, under current international law, the right to self-defense can also be invoked against non-state actors. This is the case in situations where the state from which the non-state actor's attack originates is unwilling or unable to stop the armed attack. The use of force in Syria in collective self-defense of Iraq against ISIL is a case in point. Second, The force used in self-defense should be necessary to counter the armed attack and be proportionate in relation to this attack. In addition, the force used in self-defense should be in accordance with human rights and international humanitarian law as applicable. Third, the end of self-defense as a legal basis for the use of force is also an important topic. In principle, the same criteria apply to establishing the end of an armed attack as to the beginning. We're of the view that a state has some margin of appreciation to determine whether the armed attack has really ended or whether there is merely a temporary lull. Lastly, fourthly, the Netherlands attaches great value to the requirement under Article 51 of immediate reporting to the Security Council. We did so before we started to use force in collective self-defense of Iraq in 2016. In this regard, we note that the Charter does not specify how to notify or what to include in a notification under Article 51. In our view, if possible, notification should precede the actual use of force and contain sufficient information on the intended use of force. Based on the practice of notification so far, the Netherlands would welcome more transparency and discussion within the Security Council on the notifications received. And therefore, we are grateful to you, to Mexico, that you organized this Arria formula meeting to discuss this important topic in the right forum. Thank you, Mr. Chair.
Thank you, Ambassador Selenrat, and I give the floor now to the delegation of Georgia.
Thank you, Mr. Chair. Let me sincerely thank the Permanent Mission of Mexico for convening today's Arria formula meeting on upholding the collective security system of the UN Charter, and thank Professor Modirzadeh for her excellent briefing earlier. Today's discussion is particularly timely given the increased number of communications to the Security Council on the use of Article 51 of the Charter. The UN Charter, together with the wider body of international instruments, provides us with a blueprint for conducting international relations by peaceful means without threat or use of force. The legitimate right of self-defense and authorization under Article 51 is the only exception embedded in the Charter, which must be exercised strictly in line with Charter's provisions. Collective security system of the UN Charter works only if every member fully abides by the Charter's tenets. This is especially true in light of my country's experience, which is a victim of the full-scale military aggression and subsequent illegal occupation of its two regions by the permanent member of the Security Council. Notably, following the aggression in complete disregard of the need to advance the peace process and ensure an international presence on the ground, the Russian Federation used its veto power to dismantle the United Nations observer mission in Georgia in order to avoid any type of international engagement on the ground. And we continue to face Russian illegal military presence in the two occupied regions in complete violation of Article 2 of the UN Charter, inflicting a heavy toll on humanitarian and human rights situation on the ground. And this continues during the pandemic in complete violation of the 12 August 2008 ceasefire agreement. In contrast, Georgia is using peaceful means at its disposal, including international legal remedies. After years of dedicated strife of Georgia's side for justice and accountability, the European Court for Human Rights, in its historic ruling of 21st January 2021, confirmed that the Tskhinvali region and Abkhazia are integral parts of Georgia's territory and are occupied by Russia. The court ruled that Russia exercised effective control over these regions, and therefore it was responsible for the mass violations committed against the Georgian population. So we believe this experience is something that is important as we reflect on the uses of Article 51, and we reiterate our position that any use of force has to take place in full compliance of the UN Charter, and we will continue to be engaged in the discussions on the use of Article 51. Thank you, Mr. Chair.
I thank Georgia for the remarks and give the floor to the delegation of Australia, please.
Thank you, and thank you, Mexico, for convening this important meeting today, and to Professor Modirzadeh for her briefing. Australia welcomes the opportunity to address this Arria formula meeting on the use of force under international law, including the application of Article 51 of the UN Charter. The obligation in Article 2.3 of the UN Charter to seek the peaceful settlement of disputes and the prohibition on the use of force in Article 2.4 are key pillars of the international rules-based order and essential to maintaining international peace and security. States' inherent right of individual and collective self-defence is reflected in Article 51 of the Charter. It is one of the limited exceptions to the prohibition on the use of force against the territorial integrity or political independence of another state. Australia recognises that the right of self-defence is available in respect of an actual or imminent armed attack. The right of self-defence is not unconstrained. Force used in self-defence must be necessary to address the threat or use of force, and it must be proportionate to the threat that is faced. Australia recognises that the right to exercise individual or collective self-defence is available against non-state actors in the territory of another state where those actors are involved in carrying out an actual or imminent armed attack, and where the territorial state is unwilling or unable to prevent such attacks originating from its territory. We note that in the wake of the 9/11 attacks, the UN Security Council adopted resolutions 1368 and 1373 of 2001, which recognised the right to exercise self-defence against non-state actors in the territory of another state. Finally, we refer to the important requirement in Article 51 that measures taken in exercising the right of self-defence shall be immediately reported to the Security Council. Australia underscores the importance of states complying with this obligation. Thank you.
Thank you, Ambassador Webster. And I give the floor now to the delegation of Ukraine.
Thank you, Mr. President. We would like, first of all, to thank you for organizing this Arria Formula meeting. It is a good opportunity to discuss the issue of maintaining international peace and security against the backdrop of armed attacks against the United Nations member states. By joining the United Nations, member states undertake the responsibility to act in conformity with international law, including the Charter purposes and principles. In particular, to refrain from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. This principle underlines that armed force shall not be used save in the common interest and, in principle, through the collective security system of the United Nations. Resort to force by individual states or on their own initiative constitutes a departure from this principle and is permitted only under exceptional circumstances, namely if an armed attack occurs against a member of the United Nations as stipulated in Article 51 of the UN Charter. During the San Francisco conference, subcommittee in charge of Article 2 stated that the right of self-defense against aggression shouldn't be impaired or diminished. This is particularly relevant when the source of aggression is a permanent member of the Security Council, like Georgia just recently mentioned, who systematically abuses its veto right and blatantly disregards its obligation to maintain peace and security. At the very initial stage of the Russian armed aggression against Ukraine in March 2014, the Ukrainian parliament adopted an address to the United Nations in which, in accordance with the right of self-defense, Ukraine reserved the right to request the states and the regional collective security systems to assist in restoring its sovereignty, territorial integrity, and inviolability of its borders. This address was transmitted to the President of the Security Council by the letter dated 13th of March 2014. We were forced to refer to our right to act in accordance with Article 51 on the later stages as well of the Russian aggression. It happened in particular at the Security Council meeting in August 2014 following the full-scale Russian incursion in Donbass. On numerous occasions, our right of self-defense has been reconfirmed and supported by the members of the Security Council. The Russian Federation carries out its armed aggression against Ukraine both directly and through its proxies. Russia has occupied and exercised effective control over the parts of Ukrainian territory in Crimea and Donbass. At the same time, it has created the illegal armed formations and continues to support, control, and provide them with weaponry and personnel in an attempt to conceal its own responsibility as a party to international armed conflict and its instigator. The proper response to such violations by a Security Council permanent member, damaging the credibility of the whole Security Council, should be a part of discussion on invocation of Article 51. Finally, Mr. Chair, we should admit that today the role of self-defense cannot be confined to a subsidiary one only. As long as a situation of an armed aggression by UN Security Council permanent member exists, thus undermining the ability of the Council to duly exercise its mandate, self-defense will remain the legitimate last resort for the states under attack. Thank you, Mr. Chair.
I thank Ukraine for the remarks, and now I'll give the floor to Belgium. Karen, the floor is yours.
Thank you, Mr. President. I would like to thank Mexico for organizing this meeting, as well as Professor Modizadeh for a comprehensive briefing. Belgium welcomes this opportunity for the Council and the wider membership to discuss the interrelation between Article 51 and Article 2.4 of the Charter of the United Nations. At the outset, I would like to reiterate that for my country, international law is more than ever the cornerstone of our multilateral system. By joining the United Nations and with the aim of bringing an end to the scourge of war, all member states have made the clear choice of an international order based on the rule of law as a major factor of international stability, democracy, and prosperity. Among a few key general rules, the Charter has notably established that relations between states are governed by the principle of the peaceful settlement of disputes and the corollary prohibition of the use of force. At the same time, the Charter has also recognized the inherent right of individual or collective self-defense, as provided for in its Article 51. Yet, the use of force in case of self-defense must remain exceptional, since it constitutes an exception to the general rule mentioned above. For these reasons, it is subject to the specific conditions enshrined in the Charter that must be strictly interpreted. Let me now turn to the guiding questions mentioned in the concept note. Firstly, from a substantive point of view, state practice vary regarding the information to be contained in a report submitted under Article 51. Some give sufficient details to better justify the legitimacy of their action. Additionally, since 2001 and Security Council resolutions 1368 and 1373 adopted in reaction to the September 11 attacks, the practice is that states can have recourse to self-defense in case of attacks perpetrated by non-state actors, including terrorist groups that are located on the territory of a sovereign state. Secondly, the central idea of Article 51 is that action of self-defense can be taken while waiting for the Security Council to take the measures it deems necessary for the maintenance of international peace and security. Procedurally, this implies that the Council must be informed immediately and that it should consider the matter referred to it by the report submitted under Article 51. Finally, the transparency of states' communications relating to Article 51 is important for Belgium. We would therefore analyze with interest any suggestions that goes in the direction of greater transparency and publicity of past and current reports. I want to thank you, Mr. President.
Thank you, Karen, for your remarks. Well, this concludes officially our list of speakers. India and Pakistan have requested to take the floor again. I will proceed to give them the floor for a very brief statement on that same order that we received their request, as we are running short of time. So I give the floor again to the delegation of India.
Thank you, Mr. President. I'm forced to take the floor at this late hour to refute the points made by one delegation. Their remarks have to be treated the contempt they deserve. I can only say we have been hearing such motivated and illogical rants regularly, and no one is taken in by their disinformation. In fact, today's rant, perhaps unwittingly, only supports the view on the need for extending the right of self-defense against terrorist acts and support to cross-border terror under the guise of supporting so-called self-determination. Terror acts perpetrated with the support of a state deserve decisive action under international law. The world was not just witness to the hosting of the most wanted terrorist Osama bin Laden by the state, but also the fact that thousands of UN-listed non-state actors continue to receive this state's patronage and funding. Article 51 or otherwise, India has a right to self-defense against such a state. I thank you, Mr. President.
Thank you, and I'll give the floor now to the delegation of Pakistan.
Thank you very much, Mr. Chairman. We regret having to request the floor again at this late hour to respond to the rant that we've just heard from the representative of India. It is beyond hypocritical for a state that is the biggest exponent of state terrorism in our region to give lectures to us on the threat from the menace of terrorism. While we will not dignify this diatribe with a response, all we will say is that instead of clutching at straws, India would do well to undertake an earnest introspection, forsake its proclivity to use terrorism against its own people, against the people of Indian-occupied Jammu and Kashmir and other regional states, and eschew the fascist Hindutva ideology's avowed aim to establish regional hegemony. As for Pakistan, we reserve a right to legitimate self-defense in response to any act of aggression against the sovereignty and territorial integrity of Pakistan. I thank you, Mr. Chairman.
I thank the delegation of Pakistan, and this now concludes our list of speakers. I wish to sincerely thank you all for your active participation and your engagement. And now I will give the floor to Professor Modir-Sadeh for some final comments and reflections. Professor, the floor is yours. We can't hear you. We're still not hearing you. No. Can you unmute? I'm sorry, we cannot hear you, Professor. To be some technical problems on that I am not sure if we can handle from here. Apparently you are on mute, so we in theory shall be able to hear you, but I cannot hear you.
I'm so sorry. I apologize. Okay.
Now you.
Okay.
Now,
I'm
Professor,
terribly sorry. My apologies to everyone. I had a late minute disturbance with my headphones. So I'm very conscious of the late hour, and I don't want to take any more than a little bit of time just to thank you again, Ambassador De La Fuente, and for all the colleagues who have engaged. I think that we can definitely say that the silence is broken, and that we've started here a conversation that will be incredibly valuable to continue. I think we've heard a number of different views underscoring that this is a debate that needs to continue, and that the more voices are involved in this debate, the better for all. I also heard from a number of our colleagues that the question of how the Council receives, responds to, and distributes these communications is of critical importance to many states and many colleagues. And hearing about the underscoring of the significance of the Charter values, and also the importance of states being able to react and respond to various arguments being made in the context of self-defense in real time. So thank you again for this conversation. I hope it's the first of many, and I appreciate the opportunity to engage with all of you today. Thanks again.
On the contrary, I think indeed your comments were very provocative, and we have had a very vivid and fruitful discussion that has shown us that there is a real need and a broad interest to address these issues in a transparent manner and with the involvement of all member states of the United Nations. We will prepare a summary of this event and share it with all member states, and I invite all delegations to send your written statements so that we can include them in the summary. Thank you again and have a good evening. This meeting is adjourned.